we cannot patent under section 3 and under section 4. Like under section 4 was DAE related, means atomic energy related things we cannot patent, and 3 also says that these are the various types of materials and process and products, like if it is a very obvious things or if it is a discovery, then we cannot patent. So those are under section 3 of the Patent Act. So that those things we have covered. So we'll continue from this. So I was telling this patenting process is quite a lengthy process. So here, from here, we can see that there are two routes. Yesterday I have told. Scrutinizing, then the committee will ask you the questions. So it will take your time. So normally these are the various time schedules I have given. So just you remember that if you are going for early publications and early patenting procedure also, then also it will take 2 years of time. Okay. And if you are going for normal route, the initial phase itself will be 1.5 years, 18 months. So 1.5 years it takes for all the scrutinizing and all those things. So then the processes are similar. So it sometimes sometimes they go on revising your proposals also. So it takes quite longer time. So 3.5 years. First one is 1.5 years. Other part is similar. So minimum 3.5 years to 6 years it can take for getting the patent, final patent. Okay. So I was telling that these patents are localized. So if you are going for an Indian patent, it will be applicable for India. So your patent thing will be published, and somebody, if the person is not in, you are going for an Indian patent, and somebody in US wants to make the exact product and sell, that is allowed. So no, you cannot question that person that somebody has made that product and they are selling. So they can sell it in US, but they cannot sell in India, because in India your patent will be valid. So it will not be valid. So what people want that their patent should be in many countries also, probable countries where there is a chance that somebody may make the similar product or the same product, exactly same product. So they want to apply for many countries. So if you are applying for India, and if you are applying for some European countries like France, Germany, Italy and all, then you are going to apply for US. So many countries you have to attend. So that patent fees you have to pay. So it will, that amount will go on multiplying. It's quite a good amount. So what people do, they used to go for another channel that is known as Patent Cooperation Treaty channel. So there is a Patent Cooperation Treaty. So it's an international treaty with more than 145 contracting states. So this particular treaty is having lot of countries. So if you are going through this particular channel, so your patent can be accepted in whatever countries you are choosing from that list. So you can choose many for that. So it will be, the cost will drastically reduce. Okay. So PCT is an international treaty with more than 145 contracting states. PCT makes it possible to seek patent protection for an invention simultaneously in a large number of countries by filing a single international patent application. So international patent application you can file. So if you are going through PCT, the procedure will be little more extensive. So there will be an international organization who will look after your patent, and they will go through the scrutinize the thing. Then your Indian patent procedure will continue. So I'll just tell you that way. So here I have written the granting of patents remain under the control of the national or regional patent offices in what is called as national phase. So if you are going for this PCT type of treaty for your patent also, it will be applicable in many countries, but you have to go through your country's thing. like Indian patent, whatever organization is there, you have to go through that only. Okay. So first file phase will be scrutinizing by the international committee, then the normal route will continue. So whatever the timeline I had shown in the previous slide, that will continue. So the PCT procedure includes filing. You file an international application with national or regional patent office, because always in all the countries this national patent office are not available. In India it is available, but some regional areas also, for few countries they can have the regional office also. So through that they can apply. Or WIPO organization is there complying the PCT formalities required in the one language only. So if you are going for a particular international treaty through PCT, so you can apply through one language also, because if want to have a Italian, so you may have to translate the things in Italian while applying for the Italian patent. But if you are going through PCT, you can have a own language also. They will convert it to whatever country's language is possible there. So international search will be there. So what will happen? After your filing, one international committee will be there. They will do the search for the validity of that particular thing. So International Search Authority, that is known as ISA, one of the world's major patent offices, identifies the published patent document and technical literature, that is the prior art, whatever you will be submitting, which may have an influence on whether your invention is patentable or establishes a written opinion on your invention's potential patentability. So they will to the authority that, okay, this particular patent is patentable or not. So internationally, there will be a committee, or so that is some organization will be there. They will look, you are filing an international patent. So first they will see, then they will then as soon as possible, after the expiration of some particular period of 18 months from the earliest filing date, your content of your international application will be disclosed to the world. So international publication they will have. After that, include the international publications, your patent will not be granted. It will be given to your regional or your national office. Then your normal patent procedure will also continue. The supplement, there are also sometimes some supplementary international search. This is optional. A second international search identifies at your request published documents which may not have been found in the first ISA. So if there is some additional things are there, so you can have some international supplementary internationals also. But this will again take some more time. Okay. So international preliminary examination first you can opt for. One of the ISA at your request carries an additional patentable analysis, usually on the amended version of your application. So like Indian, if you are going for a national thing, I told that the first preliminary report will be submitted. And on that basis, if something is there, you have to revise and submit. So you can ask for an international examination also, because sometimes it adds to the patentability of your product. So sometimes international preliminary exams can be opted. Otherwise, they will search their own after filing, and they will tell the national authority to continue. Then the actual procedure will start. The national phase is after the end of the PCT procedure, usually at 30 months from the earlier filing date. 30 months means how many years? More than 2 years, 2.5 years. So after 2.5 years of filing the date, your national phase will start of the application from which you claim the priority. You start to pursue the grant of your parents directly before the national patent offices. Then the national phase things will continue. Okay, so that will again will have that 2 years or 3.5 to 6 years. So first is 2.5 years plus this much of year. So lot of time it takes. So just you remember that it has some certain time limit, but internationally also you can apply through this type of procedure. Okay. So how do I protect in my invention in several countries? One I have already discussed, that PCT channel also we can opt, or you can go for direct. That is the traditional route. Also, there is a Paris Convention route. So you can directly file separate patent applications in the same time in all countries. So if you want you don't want to go to the PCT route. So you can file the same thing for different countries also at the same time. Okay. And also there is a Paris Convention route. Just remember that there is another channel is there. So no need to means know the details right now. But if you want to pursue, you can just go through the internet. A lot of informations are available. Okay. So having filed a Paris Convention country, so in the Paris Convention also a lot of member states are there. So it can your things can be patented if you are going through a Paris Convention route. Whoever countries are member of that Paris Convention, it will be applicable in those countries also. Okay, so that type of facility is there. So then file separate patent applications in other Paris Convention countries within 12 months of the filing of the first patent. So the one more channel is there. So second one is the PCT route. You can go, you can apply, you can file an application under the PCT directly or within the 12 months period provided by the Paris Convention. If you are going through the Paris Convention route also, then also you can file a PCT route also. So that facility is also they are having. So which is valid in all contracting states of the PCT, therefore simpler, easier and more cost effective. So if you are going through PCT, Paris Convention, that will have some member states. Then if you are going for a PCT route, it will have lot of states. So many countries it will cover. So that your intellectual property will be your. It will not be used by somebody else. Like I am telling that if you are going for a national patent, so if you are making a nice product, but it will be somebody cannot make it and have the application in India. But if somebody knows your because once it is published, everybody in the world will know. If somebody European country, they will exactly copy everything and they can make the product. So they will start selling. So if in India somebody is manufacturing, some company is purchasing your thing, so that company has to compete with the foreign company who is not paying you but preparing the same thing. That is there. So that's why people are going through this international routes also, means many countries. But there are certain things we need not go for international things. So it may be applicable in this particular region. So you can go for Indian patent. So most of the things from D for national patent only. So very few go for US patent and all. So like that. So this is patent PCT patenting procedure I have just written. That first you have to file the PCT application. Then that first international ISR is international search report. So international committee will be there. They will search the things and they will tell the validity of the particular patent, whether it is a patentable or not, to the international agency. Sorry, that your national agency, and finally your national phase will start. So like this, different stages are there to this particular. So this traditional route is file your local application, then you can file application to abroad. So many countries you can together you can apply, and in Paris Convention, sorry, the PCT Convention, file local, then it will go to the PCT application. International search will be there. Then optional file demand for international preliminary report you can ask for. Then the international preliminary report will be getting, and then the national phase will start. So it will be a longer one, but it will be having less cost effective. It will be compared to the other one. If you are applying simultaneously for many countries, all those charges you have to bear. So in the Department of Atomic Energy, there is a DAI IPR cell, which is looking after this patenting things. So we'll just see what is the role of this particular DAI IPR cell for patenting. So what is the function of DAI IPR cell? It is the nodal agency for intellectual properties originating from DAI units. It's aided institution. You may be knowing there are many aided institutions, like you have heard any aided institution of DAI? कोई नाम सुना है? नाइजर भुवनेश्वर और कुछ? आईजीकर नहीं, आईजीकर इज अंडर डीआई, इट्स नॉट एडेड. आईपीआर गांधीनगर, तो ऐसा है. और भी काफी सारा ऐसा है. आईओपी भुवनेश्वर इज देयर. So there are aided institutes are there. So if somebody is from that institute also, it comes under DAI IPR. Okay. Okay. So and also it covers the sponsored research. So if DAI BRNS is sponsoring something, some project, that also come under DAE IPR for patents within India and as well as abroad. So if I am working in BIRC, I have to go through DAE IPR cell only. So I cannot apply on my own because I am in a DAE organization which is having its own rules. So I have to go through DAE IPR cell. So patents referred to DAE under section is there, section 20 of Atomic Energy Act 1962 by the Indian Patent Office. This also provide guidance to Secretary DAE on intellectual property matters. So Secretary DAE is the authority in our organization. So they will suggest that whether this particular product or process is there, this is patentable or not. Okay. And also they promote awareness about IPR related activities in all of our DAE units. So these are the various functions of a particular DAE IPR cell. So what are the things DAE protect? So it intellectual property created during the process of research and development in the units of DAE that do not relate to atomic energy program are protected under protected in India. So I told that if it is not coming under the section 4 of the Indian patent law, so it can be patented. So those things which are not exactly related to atomic energy, those are DAE protect. So if somebody is working on those areas, so that can be patented. Also, all innovations that are related as well as not related to atomic energy, that is confusing, I'll tell you. So which are related and not related to atomic energy program are protected outside India in countries that allow such patenting. I told in India, this Atomic Energy Act is there. So that doesn't permit the things which is related to atomic energy to have patent. But it can be patented outside India in some other European or US, those atomic energy related things also, that is possibility of having a patent outside India. Okay. But it should not hamper the safety of the organization like that. But if it is related to India, in India, it will not be patented. But in outside India, that is possible. Similarly, if something is not related to India, but you are going for a outside patent, that also cover under DAE IPR. So how to protect your intellectual property in DAE? So if we are working in DAE, so many people go for patenting. So what is the procedure for this particular patenting procedure? So there are the following steps I have written down here. So first is the inventor files application to DAE IPR cell through unit head in the prescribed format. There are some formats are there. So they have to first file the things to the unit head. If you are working in BRC, you have to apply to director BRC because he is the unit head here. Okay. So the application will be scrutinized by DAE IPR cell. IPR cell is having a committee. They will normally sits every month for scrutinizing the whatever our applications come. So otherwise, in 2 months, definitely they sit. So they will scrutinize the thing and they will tell that whether this particular process or product can be patentable or not. So if some lacuna will be there, they will suggest something. So inventor makes a presentation of the invention to DAE IPR cell, which peer reviewed by experts from units of DAE for patent application only. So along with the committee, they ask for some experts in that field also. Sometimes I have been to DAE, in DAE that VT side आपने देखा रहेगा, VT के side में हमारा DAE का main office है. So they used to have that particular meeting in their DAE office. So where they scrutinize all the patent applications, and the patent application applicator, they used to have the presentation, and this committee as well as the experts see and see evaluate that whether that this is a good proposal or not. So recommendation of DAE IPR cell is sent to Secretary DAE for approval. I told that they suggest the things to Secretary DAE, and because Secretary DAE is the authority who tells whether this particular thing has to be patented or not. Patent application is forwarded to attorney for processing afterwards. There are various attorney. There are the designated post. See, these attorneys only are authorized to file the patent on behalf of all the DAE persons. For patent applications, final draft is vetted by the inventor before sending it for filing. So what will happen? Everything, all the first scrutinizing things will happen. Then the file will go to the attorney. and attorney will format it as per the requirement, and they will file the case on behalf of you. But they will take your opinion that whether final that patent format is you are agreeing or not. If you are not agreeing, they will modify as per your thing also. But you cannot file on your own, because if you are working outside BIRC, outside DAE, you can file the things on your own. But if you are working in DAE, Department of Atomic Energy, so you cannot find on the attorney will file on behalf of you. Okay. So application is filed by attorney on behalf of the DAE or the institute. Then the prosecution of the applications will have happen, and all that checking everything will happen, and finally the patent will be granted. And maintenance of intellectual property by means of periodic renewal. So time to time you have to renew the patent. Okay. So this is the procedure. So same thing I have just listed here in the this particular format. So the same thing we need not discuss again. So the life of the patent is 20 years. I told in the beginning also, life of the patent is 20 years from the first date of filing. So this is all about particular patents. So in the beginning, we have discussed different types of intellectual property which can be protected under this intellectual property rights guidelines. So here I have given a comparison of various means the things. Process, machine, manufactured item, composition of matter, those things are patented things. And if you are going for a trademark, it should be distinctive sign of business, which include words, names, symbols, logos like this. So these things we have discussed a little in the class also. So from this particular slide, you can get all the information together. And also the duration of the protection also I have written like that. If you are going for a patent, it will be 20 years. But if you are going for a trademark, it will be indefinitely, but you have to go for 10 years renewal. Okay, so yesterday I have told that these trademarks are for 10 years, but after 10 years you can renew the things. And also similarly, I have written that GI tags are also at indefinite, that is renewable every 10 years. So GI tags are also there for 10 years only. After that, it has to be renewed. So trade secret at the end, you can see this particular one, trade secret, it is for indefinite because it has to be kept secret all the time. You cannot reveal. So there is no period for trade secrets. But for other things, particular period there. If you are not renewing, it will be made open to the public. So anybody in that zone area of work also, they can start manufacturing that particular product or use the particular process. Okay. So these are the various intellectual properties for a comparison table. And this will be my last slide. So what are the things which are not included in IPR? I have listed here. Yesterday we have seen also already for what are the things which are not included in patents. Okay, but in this slide I have written that what are the things or it is not included in IPR, totally in IPR or intellectual property rights, the things which are not included. That I have listed here. So the first thing is natural phenomenon or discoveries. I told that patents cannot be discoveries cannot be patented. Similarly, discovery will not have any intellectual property rights. Okay, so this doesn't in discoveries because it exists in nature. So those things are not included in patent as well as in many of other things also, like trademark or this copyright. Nothing can be happen. So it is not included in IPRs. So laws of nature, natural substances, and scientific principles are not protected by IP rights. Okay. So for example, gravity. If gravity is there, so if somebody now tells us that I want to, because nobody has filed that patent or copyright or something, that now I'll be applying for that. That is not allowed. It is a natural phenomenon, or it's already existing. So you cannot go for that. Speed of light also, time to time they evaluate. If somebody is re-evaluating the speed of light and that they are getting some changes in that particular value, okay, so that also will not be patented because it is existing there and you are just re-evaluating that thing. So that will not be, these are natural phenomena, so you cannot have the right for that, those things. So it doesn't come under intellectual property rights. And also, a new mineral discovered in nature cannot be also owned. So because a lot of mining things are going on, so because we search for new minerals which will can provide that technological important things, like for if we are going for the Department of Atomic Energy, we require uranium, thorium, zirconium, niobium, tantalum. Those things type of elements are very much rare earths. All these are important for Department of Atomic Energy. And if I'm because Atomic Minerals Directorate also is there in DAE, so they are searching for new minerals all over the country, and like worldwide people are searching for that. So if somebody is getting a new mineral which has not yet means somebody has claimed that this type of mineral exists, and somebody is getting that new mineral, that also will not be coming under intellectual property because it is existing in nature. Okay. So abstract ideas also, these ideas are not protected unless they are expressed in a tangible form, such as a written down or recorded. So if somebody is having a thought, like if something will happen, this will change the social behavior of human or something like that. So means this type of abstract ideas cannot be patented because it has to be tangible. Then only I told in the beginning that these are intangible things, but now I am telling that the ideas also, it has to be come you have to make it in a tangible form, like you have to write down the things, what is the idea and how it is going to have some applicable or something, you have to write down, and you have to quantify that, or you have to tell that what is exactly it is. So abstract type of ideas, because abstract ideas are always means quite important in literary or uh, art field, those are very important. But in a way, this will not be come under India intellectual property rights. And also facts and common knowledge, like basic facts like 2 plus 2 is 4. So this is not yet patented. So somebody will tell that, okay, that is not patented, so I am going for this type of patenting. So this multiplication, addition, those things, those things also, these are common knowledge. So those things will not be patented because till now addition, subtraction, nothing is patented. So somebody will may think that, okay, these are not patented, so let us go for patenting those things, which is so those things, common knowledge will not be patented. So because they are not considered original creations, because some from means ages people are doing this. And methods, systems, and procedures, broad methods or systems are not also protected, though the specific implementation or the resulting product can be made under intellectual property rights. If it is a general type of procedure, it will not be patented. So it has to be have some novelty, as and it should be having some specific purpose or specific implementation applications. Then only it will be patented. So if it is a general broad type of thing, it will not be patented. And also names, titles, and short phrases. The like movie name. You might have seen that same movie many times comes. Devdas movie. It was there in Dilip Kumar stage also. It has come to Shah Rukh Khan also. So like this Godfather. Godfather, they made 1, 2, 3. But Godfather, you cannot do that. It will be a copyright the name or like that. trademark or that type of thing you cannot use. So names and phrases are not included in this particular intellectual property rights. हाँ, सॉन्ग्स वगैरह कर सकते हैं, हाँ। सॉन्ग्स वगैरह कर, वो तो मैंने बोला कॉपीराइट तो उसमें होता ही है, सॉन्ग्स के लिए तो होता है, बट अगर आप बोलेगा कि सॉन्ग का नेम या टाइटल कुछ रहेगा, तो दैट टाइटल के यू कैनॉट हैव द कॉपीराइट। पूरा पूरा सॉन्ग को कॉपी करने से, ट्यून को कॉपी करने से होता है। जैसे लेंथ ऑफ नो, दैट्स आई एम टेलिंग ना। Yes, that's why I'm written names, titles, and short phrases. If it is a short phrase, 2-3 words, you cannot have the patent. If it's a long phrase, you can go for the copyright of that, because for phrasing that long phrase, some intellectual property has been utilized. They tell, but a short phrase, 2-3 words, it's common to use. Anybody should be able to use that. So it doesn't come under intellectual property. Okay. So that's why I was telling, na, a lot of movies are coming with the same names. Nayak, Khalnayak, all these things are, you cannot have the patent or have that copyright of the particular name. But आपको अगर पता होगा, हेलो, आपको अगर पता रहेगा तो आप मुझे पक्का इंफॉर्मेशन दीजिए. आई विल अपडेट माय नॉलेज, बिकॉज आई एम ऑल्सो लिटिल न्यू टू दिस पर्टिकुलर फील्ड. आई एम नॉट वेरी मच acquainted in this particular all these things, because I am also learning. So if I am having the example from you, so I can update also, and next batch definitely I'll tell that. Pardon? Mm-hmm. Hmm. हाँ हाँ, कॉपीराइट शॉर्ट नेम्स में. हाँ हाँ हाँ. ओके ओके ओके. गोलमाल 2. ओके ओके ओके. हाँ. Yeah, maybe. So that's why I'm telling, na, I may not be, because these things I have taken from the internet maybe. So it is written like this. So they have written that this short slogan titles, generic names are too minimal to be protected by copyright. So those some, and afterwards they have written, though some may be eligible for trademark protection if they are distinctive and used in commerce. So this phrase also they have written that if it is a particular and it's there, in that particular case it can be protected. Otherwise, in general, the names and all short phrases, you cannot have the protection. So, yes, you cannot have, because my name, otherwise I'll patent na. Kallol is a different name. In Bengali बहुत सारा होते हैं, but I feel here nobody Kallol is there. In BRC, 2 more Kallols are there. Pardon? Yeah. Yes, copyrighted. Okay. So thank you for sharing, and because there are many things, because all these phrases you see, all these clauses have certain things on the end. Like this particular names and title, they have written that though some may eligible for trademark. So like this, the end they write something, and the end they keep those things open also. So there is the option also to have the copyright, but in general, names and all are not copyrightable. Okay. या बिकॉज जिंदगी के साथ भी जिंदगी के बाद भी, किसका होता है ये स्लोगन? LIC. तो इसको आप लेके दूसरी जगह पे यूज नहीं कर सकते हो. तो दिस टाइप ऑफ फ्रेजेस आर दे हैव द कॉपीराइट. ओके. सफेदी के चमकार ज्यादा, उजाला ना, उजाला या रिन, ऐसा कुछ होता है. तो ऐसा होता है. दैट पर्टिकुलर टैगलाइन इज sometimes quite catchy, and for having this particular tagline, they put lot of intellectual efforts. So that's why those things are protected under intellectual property rights. But normal realm, like some here Rohit Kumar and Santosh Kumar. These are, you in BRC you will get 10 names. So they cannot have the copyright of their names. So like this, many names are there in BRC. If you see few names are there are 10 persons and the exactly same names are available. Okay. एक ऐसा केस हुआ था, एक सेम डिवीजन में दो लेडी हैं, दोनों का नाम सेम है, दोनों का सरनेम सेम है। आप लोग बायोलॉजी में कोई ज्वाइन करोगे तो आपको पता चल जाएगा तो कुछ दिनों में। आप जानते हो? नहीं नहीं नहीं, ज्योति कपूर, ज्योति कपूर और ज्योति शर्मा, समथिंग लाइक दैट। द नेम्स आर सेम, द सरनेम्स आर सेम, बोथ आर वर्किंग इन द सेम डिवीजन, so they cannot have the copyright of their name, but we get confused because I get samples from both of them. Sometimes I had sent that report to one that researcher, and the next day somebody else asked me that I am sending the sample. I told that yesterday only I have reported the things. So the other person, no, I am sending the samples. Okay, how it has happened? Then I asked the name. She told the same name, but same name, same surname, it's quite rare. But I'm telling that this type of things happen, and these are not coming under copyrights. Okay. नहीं, बॉम्बे में क्या होता है, महाराष्ट्र में क्या होता है, इसीलिए पापा का नाम भी लिखा जाता है, मम्मी का नाम भी बीच में लिखा जाता है। तो मेरे नाम के अंदर मेरे पापा का नाम भी डाला था, तो मैंने बोला कि मेरे पापा का नाम तो बचपन से मेरे सर्टिफिकेट्स में नहीं है। बट इन महाराष्ट्र इट हैपेंस दैट दे पुट द मदर फादर्स नेम इन द बिटवीन आल्सो, सो यू हैव द डिस्टिंक्ट डिफरेंट। ठीक है, ओके, हम थोड़ा आगे बढ़ेंगे। So also non-novel and obvious inventions are not protected on IPRs. So an invention must be new and non-obvious to be eligible for patent and other intellectual property rights. A mere enhancement in the property of a known substance may not be eligible. So you see, many drugs are there, or many substances are they are utilized for certain applications. So if you are working in a biological field, you can say have the same molecule, just add a methyl group to that particular molecule. Okay, so this your molecule is a new molecule now, but it is acting for the same because the functionalities are same, so it is the out resulting in the same type of things, but your molecule is different. So you can tell that I have invented a new molecule and which is having the same exactly applications, so I should go for the copyrights or that intellectual property rights, but that will not be granted because it is not having that much of innovations or a new type of non-novel type of invention. It's having not having that much of novelty. Okay, because only the small part you have just added, and you are claiming that it's, yes, definitely it's a new molecule, but you have not added some which is drastically changing its property. That's why it is giving the same result as the previous one. Okay, so those things also will not be having the intellectual property rights. And also immoral and offensive material, works that are offensive and scandalous and contrary to the public order or are not protected under IP laws. So if you are some mass destruction things, if you are producing, so those things may not be getting the copyrights because it is not for good reasons. Unrecorded creative works, a song or speech that has not been recorded or fixed in a tangible medium is not protected by copyright. So musics are having the copyright, but if now in the class, let us assume he's a very good singer, so means a music composer, so he's just by in this class he is getting a tune and he is telling the friend that I feel this particular piece of music can be a good piece of music, and the friend has listened that thing, and what will that person will record that particular tune and go for a copyright for that. So this person will get angry, na? So I have created that music, but you are going for the copyright. How it is possible? Yes, that is possible because it has no, you have, if it is there in your mind, you first record it and it has to made in a tangible form. Then only you'll go for the copyright. But if it is just in your mind and if you had told somebody else and all, so some people may be knowing that it is your idea or your intellectual property, but you cannot have the copyrights for that. Okay. So if you're having something in the mind, you have to put it in a tangible form. Okay. So unrecorded creative works also will not be coming under intellectual property rights, and also recipes and ingredients. So cookbooks are sometimes having the copyrights, like various this master chef जो होते हैं उनका cookbooks release होता है, those are copyrighted things. But a simple list of ingredients or basic cooking instructions are not uh, or cannot be coming under intellectual property rights. जैसे राइस बनाने के लिए तरीका, बासमती राइस का पेटेंट है, that GI tag है, it is coming under intellectual property rights. But चावल को बनाने का तरीका, पानी डालना है इतना इतना, that process, it's a general process. You can tell that no, this timings are little different. किसी को 5 मिनट बॉईल करना पड़ता है, किसी को 5.5 मिनट बॉईल करना पड़ता है, इतना टेम्परेचर में बॉईल करना पड़ता है. So I am having the process. So you cannot have this process for the intellectual property rights. Okay. So general recipes and ingredients and all these processes will not come under intellectual property rights. Okay. So this much I wanted to share, that there are certain things which are coming under intellectual property, but there are many things which are general things or obvious things which will not come under intellectual property rights. Okay. So this much I wanted to share. So thank you. This much is my whole course also. Tomorrow I am having 2 classes. So I'll just go through the slides. All the slides I'll bring. I'll just go through the slides and I'll tell that these are the certain things which are important for your career maybe, or for your exam maybe. Okay. Thank you all.